In the fight against the Obama assault on the First Amendment, the Obama contraception mandate, 7 states now challenging that mandate in federal court. Those states asking a judge to block the rule that requires birth control coverage for employees of religious-affiliated hospitals, schools, outreach programs. The states arguing the mandate is a clear violation of religious freedom, also arguing the mandate would have a considerable financial impact. The mandate would also force religious employers to drop health insurance coverage, leading to an increase in state Medicaid enrollment and an increase in the number of patients at state-subsidized hospitals, all of which, of course, would be paid for by the taxpayers. The economic implications are immense. Joining us tonight, Alan Wilson, the Attorney General of the state of South Carolina. Good to have you with us. And Nebraska's Attorney General, John Bruning. Great to have you with us. John, let me turn to you first. Your suit is underway. One of the things, and I want to get this out of the way immediately, that I've heard from a number of legal analysts is that there is a question about the standing of the states in bringing this suit. How do you respond to that?
Well, we have standing for the same reason we had it in the ObamaCare case, and that is you're going to force employers to make a choice. They're either going to have to provide an insurance for a product they don't believe in, that they believe is morally wrong, or they're going to have to drop coverage. And if they drop coverage, you're going to have thousands of employees that end up on the state Medicaid plan. Those people are going to need care. They can't go to their employer. So they're going to go to the state Medicaid plan. They told us that argument wouldn't work in the Obamacare case. It has, it matters, and it does give us standing.
And it's before the Supreme Court, so
that's right.
Alan Wilson, your thoughts?
Well, I would concur with what General Bruning said. I mean, the states have a very strong interest in protecting and defending the individual rights, health, and welfare of its citizen and residents. And the common law and the Constitution and statutory power in our state gives at least myself, and I'm sure my colleagues in other states, very broad authority to represent the state's interest in protecting its citizens.
And supporters of the rule, including the ACLU, women's advocacy groups, say that it is clearly a matter of women's health, and therefore it is being a measure about female health. The rest of the considerations are irrelevant. How do you respond to that, Alan?
Well, I couldn't disagree more. I mean, this is about the erosion and the trampling of the First Amendment. I mean, people have a right to associate and to speak and to practice their religion, their faith, however they choose. What I'm seeing right now is this administration and the individuals behind these rules they're promulgating are basically saying that we have to erode your First Amendment liberties in order to help people. I don't think that you have to do it that way, and we have to draw a line in the sand right now in how we're going to protect our citizens.
How does this move forward now, John Bruning?
Well, we filed in federal district court here in Nebraska. We think we'll have a very reasonable shot at a fair hearing before then, but we expect that it will be appealed to the 8th Circuit. Whoever loses, this is one of those cases that could go all the way to the Supreme Court as well. You know, in the Obamacare case, it took a little less than 2 years to get all the way to the Supreme Court. We're confident that we'll be successful next month in that case, and I think we have the same confidence in this case as well.
Gentlemen, I thank you for both being with us here tonight, and as always, good talking with you. We thank you for your time. Appreciate it. John.